courts where battles reign, an industry forged in strain, protection cloaked in righteous fire, a patent's worth won't expire. Oh, Lashify, the singer's song, rights upheld where they belong. Broad gates swing for the small and free, pro-patentee, pro-NPE.
Welcome to this episode of the Patent Litigation Podcast. Today, Dr. Angela Liu and I will be discussing the new Federal Circuit decision in Lashify Inc. v. ITC to expand the definition of domestic industry, and the likely impacts of this ruling on various stakeholders. As always, the views and opinions expressed in this podcast do not necessarily represent those of Brown Rudnick. This podcast is presented for informational and educational purposes only. Thanks for joining me again, Angela.
Absolutely, Eric.
So the Federal Circuit recently issued a decision that's kind of shaking things up for patent owners looking for ITC remedies. You know the domestic industry requirement, right? It's always been this tricky hurdle, but this new ruling broadens the scope of qualifying investments, making it, well, pretty significant. And for patent holders, this could really mean a big deal.
Right. I mean, historically, domestic industry requirements could feel kind of limiting, but this decision aligns much better with how businesses operate today, especially with modern models. Like many companies now rely heavily on investments in licensing activities instead of manufacturing facilities. It helps recognize that shift.
Exactly. It opens the door for a wider range of expenditures to qualify, like your licensing, R-work, even marketing in some cases. This gives patent owners a stronger legal position to keep infringing products out of the U.S. market.
Which, let's be real, is critical. I mean, the ITC's remedies, like exclusion orders, are incredibly powerful. They basically block imports at the border.
Yep, we're talking about effectively shutting the door.
Exactly, and here's the thing. Not only is it easier for complainants, but this decision subtly puts more pressure on respondents too. The playing field shifts quite a bit here with these new interpretations. The Lashify case in particular, it's the one to watch on how this gets applied.
Yeah, Lashify Inc. v. ITC. That case really pulled it all together. It's like this blueprint now for showing how these modern investments can meet the domestic industry standard. And let's just say complainants are walking away with a much stronger hand here.
And defendants definitely won't be ignoring this trend. We're in for some interesting battles ahead.
Absolutely. And it's not just patent owners benefiting here. It's the way the ITC is adapting to the current business landscape that honestly stands out the most to me. Following that thought, let's dig a little deeper into where this all started with the domestic industry requirement. Initially, it was all about whether patent owners were actually manufacturing the patented product in the U.S., which was the core focus at the time.
Right, but over time, it started to include activities like research and development, which made sense because not all industries revolve around production lines anymore. It expanded even further later to things like licensing. That was a pretty big shift at the time.
And now it's gone even further, which honestly makes the whole process so much more flexible. Patent owners can show investments in marketing, technical support, even training, more indirect forms of investment to meet the requirement. It kind of recognizes how businesses operate today. Not everyone's running these huge factories anymore.
Exactly, and that's so important. I mean, companies that focus on design, marketing, or licensing efforts shouldn't be penalized just because they don't have a massive manufacturing operation. That's the reality of modern commerce, and the law is finally catching up.
Yeah, it's good to see. And man, the Lashify case really highlights all of this. You've got a company in beauty and cosmetics, eyelash extensions, right? And they were able to establish a domestic industry through marketing expenditures. It's not the classic factory model, but they made a solid case. Really shows where things are heading.
Totally. Lashify's approach was all about showing how their marketing efforts directly supported their patented technology. It aligns perfectly with this broader perspective on domestic industry. And it's not just about brands like theirs, it's more of a blueprint, like you said, for a lot of industries.
Yeah, and it's wild. This shift pretty much changes the strategy for complainants. They have way more leeway now in defining what counts as an investment to meet the standard.
And complainants aren't the only ones noticing this. Respondents are definitely going to have to adjust too. These kinds of cases will push everyone to think differently, challenge each other in new ways.
For sure, it's like this new era for ITC litigation. That brings us to the Federal Circuit's decision, which really takes this conversation to the next level. It's not just a small tweak, it's a major shift. We're talking about expanded recognition of costs here, like acknowledging that licensing, R, and even ecosystem building activities can now play into the domestic industry requirement. This change to me is significant.
Absolutely. And that first point, expanded recognition of costs, is a game changer. It allows patent holders to include things that were kind of, well, overlooked before. For example, investments in supply chains or partnerships might now qualify because they feed directly into the commercial viability of patented technologies.
Right? And this looser nexus requirement, that's a big deal too. You no longer need to prove such a tight connection between the patented invention and the investment activity. It's almost like the court acknowledged the complexity of modern business structures.
Exactly. That broader interpretation means companies don't have to jump through hoops to directly link every dollar of investment to specific patents. It creates a more realistic scenario for compliance and honestly brings a lot more industries into the fold. It's kind of refreshing to see that flexibility.
Totally. And the focus on licensing and ecosystem building, that's interesting too. Like, let's not forget, businesses don't always rely on production lines to show value anymore. Instead, fostering an entire ecosystem, think app developers around a software patent, can now be evidence of domestic industry.
And that creates a ripple effect across industries. Technology companies in particular might see this as an opportunity to double down on partnerships and collaborative efforts.
Which feeds into the fourth piece, policy considerations. This decision recognizes the need for the legal framework to adapt, to the realities of today's economy. It's like the court is saying, hey, we see you, we get what you're trying to do. It's modernizing, plain and simple.
And modernizing in a way that increases accessibility to ITC remedies for complaints. More industries, more case law, it's going to grow, expand. But at the same time, respondents need to brace themselves for this sea change.
Yeah, and it's already happening. Cases like Lashify are just the beginning. That shift to recognizing activities like licensing and ecosystem building really highlights how much the domestic industry requirement has evolved. But to understand just how far we've come, let's rewind a bit, back to when it all started. Originally, it was all about manufacturing. If you weren't producing the patented product here in the US, you didn't qualify, plain and simple.
It was a pretty narrow view, wasn't it? Manufacturing's still important, of course, but as industries evolved, the definition, well, it had to stretch a bit. That's when R started coming into the picture.
Yeah, and that was big. Research and development meant companies could show they were pouring resources into their innovations, even if they didn't have a factory churning out products.
Exactly, and from there you saw licensing activities getting more recognition too. That was a huge shift because, let's face it, not every patent owner is equipped to manufacture. Licensing became a way for them to, still drive value.
Right. Licensing started to be seen as a real investment, something that contributes to the domestic economy without the need for smokestacks. It was a recognition that value doesn't just come from production lines anymore.
And eventually they also started looking at indirect and overhead costs. Things like administrative expenses and support activities got factored in, which makes sense because those are real investments too, even if they don't look flashy.
Totally. It's about capturing the bigger picture, how all these efforts, direct or not, tie back to the patented technology. And it's not just about widgets or products, it's the ecosystem around them that matters. Building on these evolutions, the expanded interpretation now encourages us to recognize various expenses, costs that once were overlooked but are now seen as key indicators of real domestic industry investment.
Right? Like we're talking about marketing, for instance. Before, those expenses might have been dismissed as too indirect, but now, if the company can show they're supporting the patented technology, those costs are fair game.
Exactly. And let's not forget about administrative overhead, the kind of, behind the scenes stuff that's critical for running any business. That's finally starting to get the recognition it deserves in this context.
Totally. And it's not just fairness, it's also practicality. Companies invest in a range of activities to support their patents, even if those investments don't always scream innovation on the surface.
And this ties directly into linking cost to the patent itself. It used to be so rigid. You had to prove this really tight connection. Like every dollar spent needed a direct line to the patented invention.
Right, and that wasn't always realistic. Modern business models are so interconnected, sometimes the return on investment isn't immediate or linear.
Exactly. The broader standards now allow for a looser connection as long as the overall activity clearly contributes to the technology's success. It's not about having one-to-one proof anymore. It's about the bigger picture.
And that bigger picture leads right into licensing. Strengthening the role of licensing activities is one of the most significant developments here.
Absolutely.
Because licensing isn't just a way to monetize patents, it's also a way to effectively build ecosystems around the technology. Licensing spreads innovation, connects it to users and partners, and fuels further growth.
Yeah, and courts are finally taking those dynamics into account. It's not just about how patents are used internally, it's about how they're licensed and contribute to the broader industry. That shift is
Game-changing.
exactly. And not just for one segment of the market. This opens doors for entire industries to engage with patents in new ways, reinforcing the value of licensing as a legitimate form of domestic industry investment. And speaking of real world impacts, let's dive into the Lashify case. It's a textbook example of how the evolving domestic industry standards are shaping patent applications in unique markets. Lashify, based in California, specializes in at-home eyelash extension products like lash segments, adhesives, and these innovative applicators. It's certainly a niche industry, but a fascinating one to unpack.
Totally. And what made their case stand out is how they demonstrated domestic industry. I mean, they didn't rely on the traditional manufacturing heavy model because their focus is more on marketing and brand development.
Exactly. So, in their complaint to the ITC, Lashify pointed to investments in these areas, like marketing strategies, to show their contributions to the domestic economy. It's a really modern take on the requirement, and honestly, it worked in their favor.
Right? And the ITC bought it. Their view was that these marketing efforts supported the patented technology, which is the key. It's not just about money spent, but how that spending ties back to the success of the patent.
Exactly. And this wasn't a small victory either. The ITC agreed that Lashify's investments met the domestic industry standard, even though the focus wasn't on traditional factors like production or assembly lines.
Which is huge. I mean, it kind of redefines the game, a beauty company relying on marketing to meet domestic industry. 10 years ago, that would have seemed like a stretch. But now, it's entirely credible under these new interpretations.
And it's not just about Lashify. This opens the door for other companies in diverse industries to use this case as like a benchmark, whether it's cosmetics, tech, or I don't know, personal care.
They've got options.
Exactly, and it shifts the balance. Patent owners now have a stronger way to protect their innovations without needing massive manufacturing facilities behind them.
But let's not forget the flip side. For respondents in these cases, this decision adds, well, a whole new set of challenges. They'll need to counter these broader interpretations, and that's going to be an uphill battle in some scenarios.
Absolutely. And as more cases like this come up, the ITC's views will keep evolving. But right now, Lashify's win puts a spotlight on these new standards. It's really a case to watch. So, with Lashify's win fresh in mind, let's dig deeper into this shifting interpretation of the domestic industry requirement. This isn't just an isolated case, it impacts pretty much everyone involved in ITC litigation. And for patent owners, they're clearly among the biggest winners of this evolving standard.
Right. This new flexibility gives patent holders so many more tools to show domestic industry, like they can point to licensing deals or marketing spends that honestly might have been dismissed before.
Exactly. So now they've got more pathways to prove their case, which, let's be real, strengthens their negotiating position big time. It's almost like the ITC said, sure, you don't have a factory, but show us you're making a meaningful contribution to the US economy and you're in.
And that's really powerful. It levels the playing field for those who innovate in less traditional ways, whether it's licensing or ecosystem building. But Eric, what about accused infringers? This shift clearly puts them in a tougher spot.
Oh, no doubt. For accused infringers, it gets, let's just say, more complicated. They're now facing a broader set of criteria that complainants can leverage against them. It's like trying to defend against a moving target.
Exactly. And, companies accused of infringement are already under a lot of pressure in these cases, especially with the ITCs.
Remedies being so severe, right? Blocking imports at the border, that's not something most businesses can just shrug off.
Definitely not. It's a huge deal. And now with this expanded interpretation, infringers are going to need stronger defenses. It's no longer just about arguing against manufacturing evidence. It's everything else, too. Licensing, marketing, even partnerships could all come into play.
And you know who's also in the hot seat here? The ITC and policymakers themselves. These changes require the ITC to adapt its processes, and for policymakers, it's about ensuring these new standards don't swing too far and hurt innovation.
Right. Creating a balanced system is critical. If the market tips too heavily in favor of patent holders, it might discourage competition. On the flip side, you don't want to disincentivize legitimate innovators by making it harder for them to protect their work. It's tricky.
Totally. And then there's the wildcard group, non-practicing entities, or NPEs. This broader interpretation gives them, well, kind of a backdoor advantage. Since many of them focus on licensing rather than producing, they now have more ways to argue domestic industry.
Yeah, but that's where the debate really heats up. NPEs already face a lot of criticism for being, patent trolls. This new standard could hand them more leverage in ITC cases, and that's bound to draw pushback from, well, basically everyone they target.
For sure. It's one of those unintended consequences scenarios. On the surface, the broader criteria makes sense, but in practice, it could open the door for more aggressive tactics.
And that's where we'll likely see more scrutiny from the ITC down the road, trying to prevent these standards from being misused. But in the meantime, stakeholders from all sides are going to have to navigate this shifting landscape carefully.
Building on all those broader shifts we just discussed, let's pivot to the strategic side of ITC cases, like what patent owners need to keep in mind to get an edge and, frankly, what hurdles might trip them up. Starting with evidence of nexus. It's not enough to just spend money on some generalized activity. You've got to connect those investments back to the patented technology, right?
Exactly, and that connection can be a tricky needle to thread, but at the same time, courts have been more lenient lately, accepting broader interpretations. Still, if you don't have a solid paper trail showing how, say, your marketing spending ties into supporting your patent, you're vulnerable to pushback.
Right. Documentation is key, and it has to be specific. Otherwise, respondents are going to jump all over the lack of clarity. And timing's also huge here. I mean, if the bulk of your investments come after your complaint's filed, it's not going to look great.
Exactly. Timing matters because you have to show a sustained commitment, not just a last-minute effort to qualify under ITC standards. And it doesn't stop at finances. Expert testimony can play a pivotal role too. Having the right experts to clarify complex connections could make or break your case.
Yeah, expert testimony isn't just a bonus, it's critical. You need someone who can articulate those technical details in a way that lands with the court. And let's talk global manufacturing and supply chains for a second. With everything so interconnected these days, complainants often run into questions about where investments truly occur.
Totally. Supply chains are a double-edged sword. On one hand, they showcase how interconnected companies are, but on the other hand, they raise questions about whether those investments are actually benefiting the U.S., which is, after all, the point of domestic industry.
Exactly, and respondents will exploit any ambiguity there. And finally, there's this elephant in the room, fear of abusive claims. Broader interpretations of the law, like we've seen, could open the door for claims that push the limits of fairness.
And that's a real concern. The ITC has to walk a fine line to prevent these expanded standards from being weaponized. But until there's more clarity, we're talking about a major shift in strategy for both sides.
All right, so here's the challenge. As the law continues to evolve and incorporate broader standards, there's a growing tension. On one hand, you want to protect genuine innovation and investments, but on the other, you need safeguards to ensure these standards aren't manipulated to give one side an unfair advantage.
But on the other hand, you've got to be careful, right? You don't want businesses inflating or worse, misrepresenting their U.S. activities just to meet the standards. That's where things can get tricky.
Exactly. And that's where cases like Lashify come into play. What stood out there was how the ITC and the Federal Circuit really dug into the evidence. They weren't just taking companies' word for it. They were looking at, the specifics, making sure those expenses were tied directly to the patent.
Right, it's all about credibility. If a company claims they've spent millions supporting a patent, they need to show exactly how those funds were used, whether it's for marketing, licensing, or brand presence. Lashify proved that connection in a way that felt, well, legitimate.
Exactly. And this broader interpretation doesn't just stop at beauty products or niche industries. It reflects a larger trend. Lawmakers and courts are recognizing that today's businesses don't always fit into that traditional model of manufacturing. It's about protecting all kinds of investments in innovation.
Which makes sense if you think about it. Branding, partnerships, even online strategies, these are critical in today's economy. You can't just measure innovation by production lines anymore. That modern, broader view is why Lashify is a case we'll be referencing for a while.
Totally. It's a reminder that while the law adapts to new realities, the need for evidence and transparency has to stay at the core of these decisions. Building off that, the Federal Circuit's decision represents a pivotal shift in how the ITC approaches the domestic industry requirement. By allowing expenses like marketing, ecosystem support, even overhead to count, it's adapting to reflect the realities of today's businesses. That's a modern approach for a modern economy.
Right, and this expanded interpretation makes the ITC even more important as a jurisdiction for patent enforcement. Fast timelines, powerful remedies like exclusion orders, it's an invaluable tool for patent owners to protect their innovations.
Exactly. And for practitioners and companies looking ahead, this decision is a call to action. Documenting every investment, making sure it ties back to the patented technology, that's going to be critical.
Totally. Clear records, strategic planning, and the right evidence are going to make or break these cases. And patent owners need to view this as an opportunity to align their strategies with this broader interpretation.
And for respondents, well, it's a challenge. The door is now open for a wider array of claims. They'll need to adapt and find new ways to argue against these expanded standards.
Not to mention, this shift invites more scrutiny from everyone involved: judges, policymakers, and even the public. The key here is balance, supporting innovation without creating loopholes that lead to misuse.
Exactly. And Lashify's case? It's a blueprint for how this broader interpretation might play out in the future. It's one to keep an eye on, especially as similar cases make their way through the courts.
It really sets the tone. But, like we said, the focus has to stay on evidence and transparency. Without that, it's easy for this broader framework to become muddled.
Totally agree. So, for patent owners out there, take this as a moment to reassess your strategies. And for everyone else caught up in these ITC cases, Well, get ready. It's a whole new playing field.
And on that note, this has been a fascinating discussion. Thanks for joining us to unpack the big changes and their impact. Eric, always a pleasure.
Always, Angela. And that's all for today, folks. Stay sharp out there, and we'll catch you next time on the Patent Litigation Podcast.
Oh, Lashify, the singer's song, rights upheld where they belong. Broad gates swing for the small and free. Pro-patentee, pro-NPE, domestic walls, the ITC, a shelter built for you and